Meanwhile, Ali, in the Senate, there were some dramatic moments from lawmakers on the Judiciary Committee.
Yeah, really dramatic, really fiery. Take a look at what this hearing has looked like, and then I'll explain why. Watch.
Mr. Chairman, you just destroyed one of the most important committees in the United States Senate.
Chair would note,
and you set a precedent which will be repeated every time one party or the other takes advantage and takes the low road. It sets a precedent that will then become the norm. Congratulations on destroying the United States Senate Judiciary Committee.
I mean, this is so unnecessary. To ruin the committee over a political exercise that's going nowhere.
Destroying the Judiciary Committee, as one Republican senator was saying to the chairman, Dick Durbin. All of this is because of something that Durbin is doing procedurally, basically not letting these Republican senators talk before nominees are voted on in the Judiciary Committee. That's substantively and specifically why they're angry right now. But the larger context of this is that today in the Judiciary Committee, they're about to embark on considering subpoenas for conservatives like Leonard Leo and Harlan Crow, who are at the center of the Supreme Court ethics battle. Durbin has been leading on this, saying that he wants more testimony and more public light shed on what's going on between the Supreme Court and some of these conservative donors who people like Justice Clarence Thomas have been linked to. Republicans, of course, have been stonewalling that. So technically, this is about a procedural thing that Durbin just did, but actually, it's not, Jose.
And the destruction continues in the Senate Judiciary Committee and of our judiciary. Greetings and salutations. Welcome back. Today we're doing a little Senate Judiciary update. I'm leaving you a few clips from Senator Cruz, Holly, and of course our favorite Foghorn Leghorn Senator Kennedy from Louisiana. They seem to be the only ones asking any tough questions at all. So wanted to give you all a quick update. Be warned, the last clip is pretty graphic in nature of a sexual content. And just if you're squeamish, maybe skip the last 5-minute clip. But otherwise, it's pretty enlightening. Here we go again. But wanted to give you all a brief update on that. Got some clips on the back end. I'm going to let you have them. Here they go.
And I just want to close by this, which is urging my colleagues to be willing to stand up to the White House. I'm confident that many, if not most of you, actually care about having a qualified judiciary. One of the things I cannot understand over the last 2 years is every Democrat member of this committee has voted for every single Biden judicial nominee 100% without failing. And I will say on the Senate floor, every Democrat has voted for every Biden judicial nominee. Not a single Democrat in the United States Senate has mustered the courage to vote no on a single nominee. And to be clear, it wasn't that long ago. We had a Republican president and a Republican majority in this body, and there were many of us who said on particular nominees, this is not a good nominee. We're not going to support this nominee. In fact, the John Kennedy test that Chairman Durbin referred to came from a Trump nominee who John Kennedy eviscerated at a hearing in a video that I still liken to watching a car wreck in slow motion. It was painful. But what happened? When it became clear that this individual was not qualified for the position for which he had been nominated, the White House withdrew the nomination. And it did so after a number of us made clear we're not going to support putting an unqualified person on the bench, pull the nomination back. So I would ask members of this committee, is there anyone, if the White House nominates a ham sandwich, are Democrats prepared to rubber stamp Judge Ham Sandwich?
Thank you, Mr. Chairman. Mr. Delaney, I've been listening to your answers about your conduct in the St. Paul's case, and I have to tell you, I'm having a hard time following what it is you're saying. You've said now several times that the school only wanted the court case to be tried in a court of law, not in the media. But your attempt to strip anonymity from Chessie was exactly an attempt to try this case in the media, right? It was an attempt to bring her name forward so everybody would know who she was. She's 16. Everybody would know exactly who she was, could look her up, could threaten her, intimidate her. I mean, this was an attempt to put her squarely into the media spotlight nationally, right?
Senator, thank you for the question. I respectfully disagree that the school's intent in trying to require the lawyers to try the case in the court of law was in any way intended to intimidate any of the parties to the case.
How can you say that when you knew full well that a 16-year-old girl would have her name published, would have reporters, no doubt, in her front lawn, would have people following her around with cameras everywhere? Her family's sitting here today. They've already been through hell. Your motion was an attempt to put them through further hell in order to defend your client, right?
Senator, I was an advocate for the school.
I understand that, but as advocates, I have been too. And as advocates, we make decisions, but we're responsible for those decisions. You made a decision here. You made a decision to try to strip a young girl of her anonymity, and you effectively succeeded because you bullied her into it. So she, unwilling to be intimidated by you, went forward and revealed her own name, which took, by the way, tremendous courage. And I'd just like to honor her for her courage in doing that. But you put her to that choice. You did. That was your choice. So that's fine. You made the choice, but now you're accountable for it. So let's have some accountability here. You deliberately did this in a way that would put her at risk, and that was your intent. Have you read the letter that she submitted to this committee?
I have read the letter that was submitted to this committee.
Let me read some of it to you. She says, and I quote, "I remember so clearly reading Michael Delaney's motion from front to back when I came home from my new high school one day, processing what it meant, and then defiantly stating to my parents that after everything I'd been dragged through, from anonymous death and rape threats on the internet to the betrayal of and backlash from my closest friends at school, I wasn't going to let Michael Delaney's dirty tactics bully me, then 16 years old, into shame and silence." She goes on, and this is important. "When survivors of sexual assault, harassment, and abuse come forward to seek some semblance of justice, there is an army of attorneys with a tried and true playbook of tactics to discredit, pressure, and manipulate survivors and victims into silence." Those were the tactics that you used, Mr. Delaney.
Senator, I respectfully disagree with that characterization of the role I played as an advocate in the case. The school agreed to allow the case to proceed with anonymity. I have...
No, you didn't. You filed a motion that specifically sought to strip her anonymity. I have it right here. I've read it, and I've read your reasons for doing so. The school didn't like the time that the parents and Chessie filed their lawsuit. You complain that counsel filed the complaints minute before the clerk of the court's office closed on June 1st, 2016. Well, I'm sorry for you, but I don't understand why your inconvenience about the time should mean that this young woman should have to surrender her anonymity and have her life. She's a survivor of sexual assault, let's not forget. That already happened. You knew that. Why should she have to have her life further destroyed because you didn't like the timing of the filing?
Senator, I represented the school in that case. I did not represent the Prout family. I understood what they went through. The school felt that the request to restrict the lawyers from trying the case in the media was compatible with her desire to proceed with privacy and anonymity.
I don't understand what you're saying. You filed a motion that sought to strip her anonymity. You told the court that it should happen because you didn't like the time at which her counsel filed their complaint because it put your school at an inconvenience. They had to answer reporter questions, you said. Frankly, that seems to me like a small burden to bear after what Chessie went through. So you made the decision. You forced her to come forward. She was brave and did it, and now you're accountable for that. And quite frankly, I'm astounded you've been nominated. I can't believe we're sitting here having this conversation today. And I, for one, will not support your nomination for these reasons. People who put sexual assault victims through this kind of torture shouldn't sit on the bench. Thank you, Mr. Chairman.
Mr. Park. Would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
I've spent a lot of time studying your record. You're a bright young man. You're an activist, aren't you?
Senator, I don't think that's a fair description of my record.
Okay. You have a history of substituting your judgment for your client's interests. My impression of your record, and I've studied it carefully, is that when you think you're smarter and more virtuous than your client or the law, you substitute your own judgment. And that's a dangerous thing to do if you're a federal judge. It's a dangerous thing that you've done as a Solicitor General. Berger v. North Carolina, State Conference of the NAACP. The North Carolina legislature, elected by the people, passed a voter ID law. NAACP, as is its right, filed suit to challenge it. You were supposed to represent the people of North Carolina in the legislature. You dumped on the case, didn't you? You purposely tried to lose, didn't you?
Senator, not at all.
Well, your opponents, NAACP, filed a multitude of affidavits and expert opinions. You declined to offer a single expert witness affidavit, didn't you?
Well, Senator, let me clarify. I had no role in the trial proceedings. I'm an appellate lawyer.
Did you and your office decline to file any affidavits whatsoever?
I don't recall, Senator. I believe that is accurate, but again, I was not involved in the case at the time.
I checked. You didn't. The district court ruled for the NAACP. You didn't seek an injunction or a stay, did you?
I believe that's correct.
Yeah,
yes.
I know it's correct. You dumped on the case.
Senator, I don't think that's a fair characterization of what happened.
I do, and I think the facts bear it out. So then you take it up on appeal. In fact, the leadership in the legislature, because you dumped on the case, they tried to intervene. Said, our lawyer is not representing us, for God's sakes. They tried to intervene, the judge said no. So the case goes up on appeal to the Fourth Circuit. The Fourth Circuit reverses the district court, even though you and your colleagues tried to lose the case, and you did. It goes up to the Court of Appeal. Court of Appeal and the Fourth Circuit rules in favor of the state. You're representing the state. You tried to appeal the decision that was in your client's favor, didn't you?
Do you mean the intervention dispute, Senator?
No. You tried to reverse the Fourth Circuit that ruled in your client's favor.
Senator, that is not accurate.
Yes, it is. Yes, it is. You filed a petition for an en-banc review to overrule the panel opinion.
Senator, that's actually inaccurate. That's the intervention dispute. My office, there were two parallel appeals, and on the merits of the appeal, which we did appeal the non-entry of a preliminary injunction, and we prevailed on that appeal, working with the legislative defendants in that case.
Okay. School funding case. You were supposed to, you and your colleagues were supposed to represent the state in that case. Low-income school districts, as happens in most states, sued the state to force the Republican legislature to increase their funding. You're supposed to represent the state. You and your clients dumped on your client. You and your colleagues dumped on your client again, didn't you?
Senator, as Solicitor General Brasher told this committee a few years ago, the Solicitor General does not make those decisions.
Right. This is what you and your boss said, and it's your boss's words, but I didn't see you objecting. He said, "Today, quote, I'm gonna quote, today, lawyers from my office are arguing that we must invest more money in our public schools so our students can get sound, basic public education." Y'all dumped on your client. You did the same thing. You refused to represent the state of North Carolina in defending the law with respect to abortion, too, didn't you?
Senator, I had no role.
You knew nothing about it.
Well, I was aware of it happening,
Right.
Okay. Senator, the Attorney General.
Look, you're a smart young man. My esteemed chairman's going to cut me off, but you can't. I know you're smart, and I know you think you're more virtuous than other people, but that's a dangerous trait when you're a federal judge. I just don't think you're mature enough to be a federal judge. I don't think you'll follow the law. I think you'll try to bend the law to what you think is right. And that undermines our federal judiciary. And I don't think you've been candid with this committee. You know that, and I know that, and your record knows that.
Do you want to complete your answer to any of those questions?
Thank you, Chair Durbin. On the voter ID dispute, I think that's a helpful illustration. I had no role in the trial court proceedings. I don't even believe I was updated as the litigation in the trial court was happening. But when we had an adverse order, my role was to play a part in authorizing the appeal. I did authorize the appeal, and lawyers in my office prevailed in vacating the injunction against the voter ID law that had been entered by the district court. There was a side dispute on intervention as to whether the legislative leaders should have been allowed to intervene. I think 2 points there. We never opposed their right to intervene. I told the Supreme Court that in a brief that I signed, that we do not oppose their right to intervene. And we also said in a brief that I worked on and authored large parts of, I substantively defended the voter ID law. I explained that the voter ID law was compliant with Supreme Court precedent and that we were prepared to defend it below and that we would do so. And I remember drafting this part of the brief, extensive argumentation about why the voter ID law in North Carolina was constitutional.
Mr. Chairman, can I respond? Please?
Sure, go ahead. Take 30 seconds.
I will. Look, Counselor, those are pretty words, but I'm going to tell you something. I've studied your record. And if I hired you as a lawyer and you did to me what you did to your client, the people of North Carolina, I'd have brought you to the Bar Association. I'd have filed a complaint against you for violations of the Code of Ethics.
Now recognize Senator Ossoff, and I apologize for favoring Senator Butler as usual. You should have been.
Shogun, when you were here last year, a number of senators asked you, including me, a series of questions about articles you'd written, public statements you had made on social media that were, I have to say, pretty grossly partisan, and I thought offensive, and you and I went back and forth about it. After that, a number of us asked you questions for the record relating to these statements. I want to follow up on one of them. I, in particular, asked you to give us a full accounting of the public posts that you had made on Twitter. You had locked your Twitter account before you came before this committee. It had previously been public. I asked you to provide the public posts that had previously been available on Twitter because the ones that we have were pretty disturbing. You responded as follows, and I quote, "My personal Twitter account is comprised of posts about my mystery novels, events at the White House Historical Association, Pittsburgh sports teams, travels, and my dog," end quote. Is this an accurate statement?
Yes, Senator.
I just remind you, you're under oath. Is this an accurate statement?
Yes, Senator.
Well, let's talk a little bit about your Twitter posts then that I was asking you about. On February 18th, 2022, you posted on Twitter bemoaning the dropping of mask requirements for children, including those under the age of 5. Do you remember that post?
No, Senator. Those tweets were in my personal capacity.
No. I asked you, would you give all public posts that you had made on Twitter? You said no, effectively, and you said that your Twitter posts consisted of mystery novels, events at the White House Historical Association, Pittsburgh sports teams, travels, and my dog. And you just told me now under oath that you stood by that. So now let's talk about your Twitter posts. On February 18th, 2022, you posted bemoaning the fact that mask requirements for children under the age of 5, one of whom I happen to have, by the way, had been dropped. Is that a post about your dog or sports teams?
My social media is in my personal capacity,
Answer
Senator.
my question, please, because you've testified under oath that you only posted about your dog and sports teams and novels, and you also said you wouldn't give this committee any of your public posts. So, is your post on February 18th, 2022, bemoaning the lifting of mask requirements for children under the age of 5, who I might just ask, all of the data has said is extremely harmful to children, these mask requirements? We'll leave that aside for now. Is that a post about your dog or sports teams? Yes or no?
My social media is in my personal capacity, Senator.
Yes or no, Ms. Shogan? You are under oath before this committee, and I have to say, you have placed this issue squarely in record by repeatedly refusing to answer. Yes or no?
My social media is in my personal capacity, Senator.
So you're not answering my question. Let's talk about another post. 26th of May, 2022. You talk about an assault weapons ban, retweet a post, ban assault weapons now. Say you agree with this idea that you have to be a certain age to buy so-called assault weapons in America. Is that a post about sports teams or your dog or mystery novels?
My social media is in my personal capacity, Senator.
What about the post on January 5th of 2021 in which you say that Ted Cruz ought to stay in his own lane and not worry about what's going on in Pittsburgh? This is a reference, I think, to questions he had about the certification of the last election. Is that a post about your dog or sports teams or mystery novels?
My social media is in my personal capacity, Senator.
What about the post, you remember December 10th, 2020, where you said that you were hoping that President Trump would have his vetoes overridden, and you agreed with the post that he was a weak policy president? Is that a post about your dog or sports teams or mystery novels?
My social media is in my personal capacity.
What about your post on January 5th, 2021, in which you speculated that President Trump would pardon himself next, participating in a conversation about the certification of the Electoral College? Is that a post about sports teams or mystery novels or your work at the White House Historical Association?
My social media is in my personal capacity, Senator.
What about the post? Do you remember this one? I said we seem to be having an incredible case of amnesia, but maybe you remember this one. This is from December 3rd of 2021, in which you advise an individual who goes by Meg on social media that the Library of Congress, you advise this person to complain about religious flags that have been planted on the grounds of the Library of Congress, and you say that they ought to be removed. And you go on to give this person advice about how to complain and have them removed. Do you remember that post?
My social media is in my personal capacity.
Do you remember the post?
My social media is in my personal capacity, Senator.
I have to say, I have been here for 4 years in the Senate. I have never seen a witness stonewall like this before. Never. And I've seen a lot. This is extraordinary. Do you remember this post? December 3rd, 2021.
My social media is in my personal capacity, Senator.
I mean, this is unbelievable. And you want to be the archivist of the United States. You lied to us under oath. You lied to us in your QFRs. You just lied to me a second ago under oath. And now you're sitting here stonewalling, not answering questions about public posts that you've made. Are you a lawyer, Ms. Shogan?
No, Senator.
Are you familiar with the Shirtliff case at the United States Supreme Court?
No, Senator, I'm not.
Well, in that case, the Supreme Court held that, in fact, it constitutes viewpoint discrimination for a government entity to remove religious flags from its property when it's opened up the property to allow other people to put flags on it. Exactly the question that you are addressing in your public posts on Twitter. You're giving legal advice, which you're not qualified to give, directly contrary to the United States Supreme Court. I just wonder, does this have to do with your view that you wrote about that the religious right is connected to the rise of anti-intellectualism in American politics? Is that why you said what you said about religious flags, that the religious right is a force for anti-intellectualism? Explain that to me.
No, Senator.
Do you stand by your comment that the religious right is part of the rise of anti-intellectualism in American politics?
Senator, that article was written. It was about how Republican presidents use common sense terminology to effectively communicate with Americans.
Yeah, in which you said that the religious right, the rise of the religious right is part of the rise of anti-intellectualism in American politics. I just point out that's the article in which you say anti-intellectual, the title is Anti-Intellectualism in the Modern Presidency, Republican Populism. Very nonpartisan. Dr. Shogan, I'm going to ask you again, will you give to this committee your public posts on Twitter? Will you make them available to this committee?
My social media is in my personal capacity.
Mr. Chairman, I have to tell you, this is the most extraordinary thing I have seen in my brief time in the Senate. I have never seen a witness blatantly lie under oath like Dr. Shogan has just done to this committee, stonewalled this committee, and just repeatedly refused to answer my questions about her own posts that are in public. For these reasons, I will oppose your nomination, and I strongly, strongly urge this committee to take action on this and force this witness to own up to the fact that she is misleading us right now before our eyes, Mr. Chairman.
Mr. Chairman, I confess I'm a little confused, and I appreciate the argument or discussion that we've been having, but for me, it's a little too conceptual or, I don't know, metaphysical or theological or whatever you want to call it. I want to try to understand what you're asking us to do. Let's take two books that have been much discussed. The first one is called All Boys Aren't Blue, and I will quote from it. I put some lube on and got him on his knees, and I began to slide into him from behind. I pulled out of him and kissed him while he masturbated. He asked me to turn over while he slipped a condom on himself. This was my ass, and I was struggling to imagine someone inside me. He got on top and slowly inserted himself into me. It was the worst pain I think I have ever felt in my life. Eventually, I felt a mix of pleasure with the pain. Close quote. All Boys Aren't Blue. The second is another much discussed book. I'm sure you're familiar with it. It's called Genderqueer. Okay. Let me read an excerpt from that. Quote, I got a new strap-on harness today. I can't wait to put it on you. It will fit my favorite dildo perfectly. You're going to look so hot. I can't wait to have your cock in my mouth. I'm going to give you the blowjob of your life. Then I want you inside of me. End quote. Now, Mr. Secretary, what are you asking us to do? Are you suggesting that only librarians should decide whether the two books that I just referenced should be available to kids? Is that what you're saying?
No.
Okay. Tell me what you're saying.
Well, first of all, there's this...
Don't give me a speech. Tell me what you're asking me to do.
With all due respect, Senator, the words you spoke are disturbing, especially coming out of your mouth is very disturbing. But what I would also tell you that we're not advocating for kids to read porn, to Senator Booker's point.
What are you advocating for?
We are advocating for parents random parents not to have the ability, under the guise of keeping kids safe, to try and challenge the world view of every single manor on these issues.
You're getting conceptual game.
I'm not getting conceptual.
Well,
I'm saying
yes,
that
you are. Yes, you are. Because I want to know what you're recommending. It sounds to me like what some of you are saying, the librarians should decide who gets to see that book.
I'm saying when individual parents are allowed to make a decision of where that line is, and To Kill a Mockingbird, which involves a rape scene, should that book be pulled from our libraries? I think it becomes a slippery slope.
I think you ought to think about it a little bit more before you come here.
I've thought about,
if
Senator,
you're going to propose something, you ought to be able, in 30 seconds, to be able to explain what you're asking us to do. Ms. Kelly, what do you understand? Well, let me skip you for a second. Mr. Cameron, tell me what you're proposing.
It's pronounced mix.
Mix? Is that how would you like me to refer to you?
Senator, your definition of sexual is synonymous with LGBTQ identity.
I'm not asking you that. I'm asking you to tell me you read those two excerpts.
Genderqueer.
Do you think that, are you asking that only librarians and not parents have any say in whether minors can read those books? Is that what you're saying?
Genderqueer has never been in my school library, so it's never been banned.
Well, suppose it was. Should it be up just to the librarian, or should parents have a say?
There should be facilitation of collaboration between students,
parents have
and
a say?
Parents should be working with students and educators to be making decisions, because students are...
And who decides ultimately? The librarian, or do you take a vote, or who takes the vote?
Book review committees in the community in my school district.
You want a committee to decide?
There are committees.
Okay. Well, I'm asking you, how do we decide whether the two books that I just referenced should be available in the library? What would you, if you were running things, what would you do?
All Boys Aren't Blue, the scene you mentioned, is about sexual abuse.
I know what it's about.
It's not
What
erotic.
would you do in terms of making the books available? Would you say anybody can see them, or they have to be in a special session?
Students who do not read books like All Boys Aren't Blue cannot learn what is appropriate.
I understand that.
They cannot learn.
I understand, but none of you want to
abuse.
answer my question. You come here and you say censorship is bad, and of course it's bad. But the obvious response is, okay, you heard the books we're talking about. Okay, we're not talking about Catcher in the Rye. So tell me what you want, who gets to decide. And all I've heard is the librarians. And parents have nothing to do with it. And if that's your response, what planet did you just parachute in from?
Parents, Senator...
Or what country, more appropriately? This is not China.
Parents, Senator, for all due respect, parents absolutely have a say. My parents were immigrants, came to this country. We never checked out books without our parents seeing what books we were reading. They encouraged us to read books.
Mr. Secretary, I understand this is good for your politics back home.
It's got nothing to do with my politics. My bill is passed.
Of course it does. It has everything to do with your politics.
I'm here to...
But you came here with a problem, and I'm trying to understand the solution, and you don't have one.
We solved the solution.
Other than to tell us that we don't agree with you, we'll be on the wrong side of history.
We solved the problem in Illinois. We fixed it because we
well, there are others you could work on.
Well, that's why I'm here to help.
Thank you, Mr. Chairman.
To help other states make these decisions.